Any mention?
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 11, Your Lordship.
Yes.
I pray this matter may come up after 2 weeks, Your Lordship.
Objections, Lordship. Request the petition. Yes.
Much obliged, Your Lordship.
May I please, Lordship. Yes. Lordship, I beg to mention item number 5, Lordship. Yes. Lordship, the Karnataka Council is under some personal difficulty, Lordship. If this matter can be taken up after the Easter vacation, Lordship. I'm for a petition, Lord. No objection. No. So you'll have it after 2 weeks. Lordship. Can it be on 3 weeks, Lord? 3 weeks. 3 weeks. Okay. And the request made by Mr. H. Karwana, Leonard G. appearing for the state respondents. Not objected to by the Learned Counsel for the petitioner. This is matter after 3 weeks. Yes. Highly obliged.
May I please, Your Lordship, I beg to mention item 12, Your Lordship.
Item?
12, 1, 2, Your Lordship.
Yes.
May this matter come after 2 weeks, Your Lordship.
No one is appearing for the
No
respondent?
one, Your Lordship.
Notice was served?
Pardon, Your Lordship.
Notice was served?
Yes, Your Lordship.
You want it after 2 weeks?
Yes, Your Lordship.
Yes.
Much obliged, Your Lordship.
May it please, Your Lordship. Lordship, I beg to make a mention item 10. Item 10, Your Lordship. Lordship, yes. I'm for private respondent, Your Lordship. Lordship, I seek for 2 weeks accommodation, Your Lordship. Lordship, I put a petition at Lordship. So time may be given. Okay. The respondents. List of yes, highly obliged, Lordship. Much obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 6 and 7. Lordship, the matter is pending before the Supreme Court.
Matters, the same matter is pending, or there is a connected matter?
They have challenged the order of the division bench, my lord. This is a recruitment, this is a promotion matter, my lord. So a group of the employees, my lord, they have approached the Supreme Court in this matter, my lord. It's a transport
those who are
department.
similar situated with the petitioner.
They have been affected, my lord. This group of people
So
were
there's a
affected,
connected case pending,
my lord.
The Learned Counsel, appearing to the party submit that the commented matter pending before the Apex Court is yet to be disposed of. In view of the submission made, list this matter after
4 weeks, Lordship.
4 weeks.
To avoid the outcome of the matter pending before the Apex Court. Yes.
Obliged, Lordship.
Supplementary causeless, item number 1.
Yes, 1 minute. Let the file come.
Yes.
Yes.
The Power Grid, my lord, has filed this petition under Article 227,
Yes.
challenging the order of the Commercial Court in execution petition number 2 of 2024, my lord, which is dated 5th February 2025. Now, if your lordship will kindly see the order of the impugn order, which is at page
Wait,
3-1.
just a minute. There appears to be caveat in this matter.
I'm sorry, sir.
Caveat, you have been subbed with the notice. Yes. First, you come to just a minute. Let us pass the order in caveat. Yes, caveat. Caveat petition 27 of 2009. Mr. VK General, Learned Senior Counsel. The caveat submits a copy of the connect CRP number 7 of 2025 has been sub of the caveat. Stop. Immediate the submission. The caveat stands discharged. Yes. Yes, Mr.
Yes, my lord. Lordship, kindly see the order at page 319, my lord, of the Commercial Court. The order is dated 5th February 2025, my lord.
Yes.
Now the issue is, my lord, issue in this case is execution of an arbitral award.
Yes.
19 at 320, my lord.
Yes.
The issue in this case is the execution of the arbitral award, my lord. The case of the petitioner before your lordship is that the order, impugn order, has gone beyond the decree or the award in directing the payment of interest on pre-arbitral award, pre-arbitral award. So the direction is to pay interest on interest. Interest on the principal sum pre and post arbitral award by the executing court.
Yes.
My case is, my lord, that the arbitral tribunal has not awarded interest on pre-award in the pre-award period or post-award period on the principal amount. No interest on pre-award and post-award on the principal. No interest on the interest in pre-award period, my lord. Kindly see the
interest was awarded. No pre-award interest was awarded.
No, pre-award interest was awarded, but pre-award interest on interest was not awarded. Interest on interest.
Yes.
Before I take to the impugn order, my lord, first I'll lordship kindly see page 68. What is awarded by the arbitral tribunal? That will make the factual aspects clear, my lord. Page 68. Award starts from page 22, but the direction is at page 68.
Yes, please.
68, your lordship.
Yes.
Page. The lordship will skip the 6 line from that. Unanimously award a sum of, your lordship may kindly mark, award a sum of 1,31,87,889 in favor of the claimant and direct that respondent shall pay the claimant in full and final settlement of all disputed claims brought before us for adjudication under the present reference. We also award and direct the respondent shall pay simple interest of 12% per annum on the awarded amount from 1,26,55,793 against claim number 1,2,3,4,5,6 and on awarded amount 5,32,096 in claim number 7 from 5/7/2013 and from 21st March 2015, respectively, being the date of submission of SOC for claim number 126 and claim number till the date of payment of awarded amount by respondent to the claimant. Within 90 days on receipt of this award, this rate of simple 12 interest, however, increased to 2% per quarter every delay, 18%. So in my submission, my lord, the tribunal has directed, arbitral tribunal has directed interest of 12% on 1,26,57,793 from the cause of action in this case is 5th July to 2013.
Yes, sir. Please continue.
Yes, and on 5,32,096 from 21st March 2015 till the date of payment, my lord. That is the plain and simple the inference one can draw from the award, my lord. Now, dispute which has arisen between the judgment debtor and decree holder is this, my lord, that the decree holder is saying that on the date of award, that is 30th December 2016, the interest should have been added into the principal. That is, interest of 12% should have been added in 1,26,55,793. and thereafter the both principal as well as the interest component should have been paid interest. The case of the claimant, the decree holder, is that interest should have been added in the principal amount on the date of award, and post award the interest should not only be paid on the principal amount but also on the interest component, which is added, and it will become principal on the date of the award.
Yeah.
That is the case. My case is, my lord, that the tribunal has exercised the discretion and has awarded the interest from the date of cause of action till date of payment on the principal amount only. No interest has been awarded on the interest. My case is this, my lord. Now, the decree holder, my lord, kindly see now in that context, kindly see the judgment, impugned judgment, my lord, 319, 320.
Yes.
Case 320. This case has come up for orders on the objection filed by judgment debtor to the calculation submitted by decree holder. Page 320, lordship, what the page?
Yes.
The brief fact is that Mega Electrical, as decree holder, has filed instant execution petition for the judgment and order dated so and so. My lord, your lordship may skip that part. The second paragraph, the breakup of the amount as submitted by decree holder is as follows.
Yes.
Total amount awarded on claim number 126, 1,26,55,793. Amount awarded on claim number 7 is 5,32,096. Total pre-award interest, my lord, on 1,26 lakh is 52,96, and on 5,32 is so total pre-award interest is 54,10,472, and total sum awarded by tribunal on the date of award is, as per the decree holder, my lord, is 1,85,98,000. And decree holder says, my lord, that the interest will be paid on post award interest will run from the date of the award, that is up to, and that this is the and total outstanding claim as per the decree holder is, my lord, interest on interest. The question which fell for consideration before the arbitral before the commercial court, executing court, my lord, is whether interest is liable to be paid on interest or not when the arbitral tribunal has awarded interest only on the principal amount pre and post award. The interest cannot be added to the principal amount because the arbitral tribunal has awarded interest on the pre and post on the principal sum only, not on the interest, my lord. This dispute arose, my contention, my lord, has been noted.
Where
at
is the disputed part here? The
disputed part, if your lordship will kindly see.
Calculation which you are disputed, where it is reflected here?
Yes, my lord. Your lordship will see that this is the contention of the decree holder, my lord.
Yes, and which part you dispute? This is the contention.
This part I dispute, my lord, if your lordship will 321, second line. 321.
Yes.
321, it says total pre-award interest 1 plus 2, because the cause of action for claim number 1 and claim number 2 are different. So total is 54,10,242 is the interest component. Now kindly see this line. Total sum awarded by tribunal on the date of award, that is on 31st December 2016, is 1,85,90,131.
Yes, so
What has been?
That is what you are disputing.
Yes, I am saying that interest cannot be added into the principal sum. And the kindly see now C also. Post award interest. When the interim payment was made at the rate specified in the award of
according to you, pre-award interest cannot be included with the sum of award, isn't it?
Yes, this is my precise case, that pre-award interest could not have been added into the awarded principal amount. Could not have been added because the arbitral tribunal did not add the interest by passing the order that interest will continue to run till the time I make the entire payment. interest will continue to run on the principal amount, not on the interest component of the principal amount, my lord. There is no direction to that effect. So now I have my contentions have been noted by learned commercial court at page 322, my lord. At the foot of the page of 322, 320, sorry, at the foot of the page of page 321, contention on behalf of the judgment debtor. So same contention has been recorded, my lord, and entire amount which I have paid, my lord, is also recorded. If your lordship will see middle of the page of 322.
Yes.
Therefore, the award is for total sum of component A and B is 1,31,87,000 so and so.
Yes.
Pre-award interest for component A 53 and pre-award interest for component so and so. Therefore, total pre-award interest is so and so separately. It is submitted by Mr. Khera that principal amount would remain 131,87, which is the arbitral amount, since the simple interest is the term used for the award itself. And then, my lord, in terms of everything, my lord, based on that, payment has been made by me at page 324, my lord. Phase 324, time to time payment has been made 320. If your lordship will see the total payment which I have made at 321, kindly, sorry, my lord, kindly see the what in terms of award I have made the payment also at 321. Your lordship kindly see the last paragraph of page 321.
Yes. So decreased and satisfied with this amount, according to
yes,
you.
I have paid this amount, 2.98 lakh rupees, my lord.
So that covers the total decretal amount, including interest.
That covers the total decretal amount. Now,
Yes.
if you also will see, the reliance has been placed by the decree holder, my lord.
Yes.
At page 3 and on had a judgment of the Honorable Supreme Court in Hather Consulting, my lord. Kindly see page 325.
Okay. That's fine.
Now, if your lordship, the pointed query was, what is the dispute? 325. If your lordship will see, the decree
Yes.
holder has 325. I learned counsel for the decree holder submits that there is no dispute with regard to calculation of pre-award interest on claim number 1 to 6 and 7, which comes to 54 lakh so and so. There is also no dispute that total claim amount is 1,31 lakh. Dispute starts from the point of post-award interest commencing 31st December 2016 to 27th August 2019 is calculated by decree holder only on the principal amount of 131, which otherwise ought to have on rupees of 1,87 lakh if so calculated post-award interest so and so. Ought to have been, and total outstanding amount on 27th August 2019 ought to be 2,69 plus the interim payment of so and so amount. Your lordship may skip and then kindly come to the bottom of the last line of the page. The judgment debtor on to 61/7 has paid 2,98,94,000. As such, balance outstanding amount on 16 July 24 is 1,44,87,165, and further decree holder is also entitled to 18% on the balance payment of one from 16/7/2000 at the rate of 7,144.35. So the issue, the disputed amount before the commercial court was this, whether 1,44,165 plus 7,144 from the date of this is the now reasoning of and decision of the court, my lord, at 326.
Yes.
The court shall first address the contention of judgment as to whether the decree holder by withdrawing sum, because the principal amount was withdrawn, my lord, to the extent of 32,97,90,72. So once the principal amount was withdrawn, I said that now principal amount has come down. That is the first contention raised. Pursuant to order 27th August 2019, also accepted the fact that total sum awarded to decree holder is 1,31,87,000 as opposed to column execution petition. I am unable to agree that such a submission made on behalf of the debtor is not supported by any law. The principle is, my lord, I have paid because the arbitral tribunal has directed me to pay the interest if I on the principal amount if I don't pay the Principal amount, I paid 32 lakh rupees when I made a challenge. I led a challenge to under 34. The stay was granted subject to payment of 32 lakh. That 32 lakh has been adjusted against interest, whereas my case is that it should have been adjusted against the principal, and accordingly there should have been corresponding decrease in the interest component. That is one part of the matter, my lord. Second important part is this court shall now address the second contention raised by the judgment debtor. Interest either pre-award or post-award cannot take the color of principal amount, which is 1 crore 31 lakh, since the formula adopted as directed by arbitral tribunal is that of simple interest and not of compound interest. Now, the Honorable Commercial Court relies on this issue has been decided by Honorable Apex Court in Hyder Consulting versus so-and-so, which was subsequently upheld in UHL Power in so-and-so. In Hyder Consulting, the Apex Court has held there is no distinction between sum with interest and sum without interest. Once the interest is included in the sum for which the award is made, the original sum and interest component cannot be segregated and thus be independent of each other. Interest component then loses its character of an interest and takes the color of sum for which the award is made. The decision of the Hyder Consulting versus State of Odisha, Power so-and-so. Then the relevant paragraphs of the Hyder Consulting as has been quoted by the learned commercial judge. And then at the page 328, I'll take your lordship to the Hyder Consulting and also the relevant judgment. 328 at the bottom. In view of the settled position of law, as laid down in the aforesaid judgment, this court is of the view that arbitral award is made in respect of sum which included interest, and it cannot be said that what is being granted is interest upon interest. The third contention raised by is that principal amount which interest is calculated, etc. So based on the Hyder Consulting, my lord, my case was rejected. It was said that the Hyder Consulting has held that interest will become sum, interest will become principal sum, and therefore I am liable to pay interest on the interest component on the date of the award. That is the finding of the commercial court, my lord. Now, this Hyder Consulting, my lord, was subject of 2-3 judgments of the Honorable Supreme Court, but the leading judgment on this aspect, which has considered this very particular aspect, is the judgment of the Honorable Supreme Court in Morgan Securities, my lord, I have prepared a compilation of the judgment. And this precise issue was considered. My colleague will hand over the compilation, my lord. Lordship will kindly come to serial 8 of the compilation, my lord. Serial 8 at page 139, where the Morgan Security judgment is there, my lord. Kindly see the paragraph 1 at page 123, my lord. This is the judgment which explains Morgan Hyder Consulting, my lord. This is judgment of 2023, 1 SCC 602, my lord.
You're referring to page?
Page 143.
Yes.
143, my lord, paragraph 1. What was the issue before the court? At last line of the paragraph 1, at the core, the issue is whether arbitrator has the discretion to grant post-award interest only on the principal sum.
Okay, please.
Sorry, fourth line of the paragraph 1. At the core.
Yes.
The issue is whether the arbitrator has the discretion to grant post-award interest only on the principal sum due under section 31(7)(b) of the Act. So the issue which was precisely framed, whether the arbitrator has the power to grant interest only on the principal sum or not, which has been done in our case, my lord, that the interest has been awarded only on the principal sum, not on the interest component. This was the precise issue. And if your lordship will see the arguments at page 145, submissions of the councils are.
Yes.
Paragraph 9.5. The arbitrator has the discretion to determine the rate post-award interest. Arbitrator does not have the discretion to determine the sum on which post-award interest is to be granted. (10.2), Your Lordship, kindly, and I'm just showing the submission for the sake that what was the issue before the Honorable Supreme Court. 10.2, my lord,
Yes.
under section 31(7)(b) of the Act, the arbitrator has the discretion to grant post-award interest, determine the quantum over which the post-award interest should be granted, and determine at the rate which the interest should be calculated. So this is the submission which was, these are the submissions made in the case of Morgan Securities Credit, my lord, because this was the issue which was there before the Honorable Supreme Court, my lord. Now, Honorable Supreme Court, after examining all these aspects, in paragraph 23 at page 151, my lord, at page 151.
Yes.
The decision in Hyder Consulting
Yes.
was on a limited issue of whether post-award interest could be granted on aggregate of principal and pre-award interest. So the issue in Hyder, whether interest on interest can be awarded by arbitral tribunal or not. That was the issue in Hyder Consulting, whether the arbitrator has power to grant interest on interest or not. As noted above, the opinion authored by Bobde J was limited to this aspect of post-award interest. It was in the concurring opinion of Sapre J that was held that the arbitrator only has the discretion to determine the rate of post-award interest. Therefore, the issue of whether the arbitrator could award post-award interest on part of aggregate sum was not conclusively decided in the opinion forming a part of majority in Hyder Consulting. So what Honorable Supreme Court says in this Morgan, my lord, is that the Hyder Consulting is not the authority on the proposition that interest and principal have to be clubbed together and the arbitrator has to award interest on interest. The issue in Hyder Consulting, as per the Honorable Supreme Court, was only whether the arbitrator has power to grant interest on interest or not. And in the Honorable Supreme Court held in Hyder Consulting that the arbitrator has power to grant interest on interest. Now the question, the issue before us is whether phrase unless the award otherwise direct in section 31(7)(b) of the Act only provide that the arbitrator the discretion to determine the rate of interest or both the rate of interest and the sum it must be paid. At this juncture, it is crucial to note that both clause A and B are qualified. While clause A is qualified by arbitration agreement, clause B is qualified by the arbitration award. However, the placement of the phrases is crucial to their interpretation of the words unless otherwise agreed by parties occurred at the beginning of clause A, qualifying the entire provision. However, clause B, the words unless the award otherwise directs occur afterwards, a sum directed to be paid by arbitral tribunal shall before the word carry interest at the rate of 18%, thereby those words qualify the rate of post-award interest. Paragraph 25. Section 31(7)(a) confers a wide discretion upon the arbitrator in regard to grant of pre-award interest. Arbitrator has the discretion to determine the rate of reasonable rate, the sum on which interest to be paid. May Lord kindly mark this line, sum on which the interest is to be paid, and that whether or whole or in the part of principal amount, and the period for which payment interest is to be made, whether it should be for the whole or any part of period between the date on which cause of action arose and date of award. While discretion has been conferred on the arbitrator in this regard to grant of pre-award interest, it would be against the grant of statutory interpretation to presuppose that legislative intent was that to reduce the discretion power of arbitrator for grant of post-award interest under clause B. Clause B only contemplates a situation where the holder is entitled to post-award interest of 18%. Sorry, award is silent on the post-award, in which event so and so. The arbitrator has the discretion to grant post-award interest. Clause B does not fetter the discretion of arbitrator to grant post-award interest. It only contemplates a situation in which discretion is not exercised by the arbitrator. Therefore, observation of Hyder Consulting on the meaning of sum will not restrict the discretion of arbitrator to grant post-award interest. There is nothing in the provision which restricts the discretion of the arbitrator to grant post-award interest, which arbitrator otherwise holds inherent to their authority. The purpose of granting So the after the 27, the purpose of granting post-award interest is to ensure that award data does not delay the payment of award. With the proliferation of arbitrary issues involving both high and low financial implications are referred to arbitration. Arbitrator takes note of various factors such as financial standing of the award data and circumstances of the parties in dispute before the awarding interest. Discretion of the arbitrator can only be restricted by express provisions up to that effect. Clause A is subject to the exercise of discretion by arbitrator on the grant of pre-award interest to arbitrator. However, there is no provision in the Act which restricts the exercise of discretion to grant post-award interest by the arbitrator. Arbitrator must exercise the discretion in good faith, must take into account relevant, must reasonably. Now, conclusion, my lord. 28.1. In view of the discussion, we summarize our findings below. The judgment of two-judge bench in SL Aurora was referred to three-judge bench in Heather Consulting on the question whether post-award interest could be granted on aggregate sum of the principal and the pre-award interest arrive under 31(7) or not. So the question which fell for consideration of the Honorable Supreme Court in Heather Consulting whether arbitrator has power to grant interest on pre-award interest or not. The phrase unless otherwise direct in 31(7)(b) only qualifies rate of interest. The phrase unless, according to section 28.4, according to section 31(7)(b), if the arbitrator does not grant post-award interest, award holder is entitled to post-award at the rate of 18%. 28.5, my lord, this is most important. Section 31(7)(b) does not fetter or restrict the discretion that arbitrator hold in granting post-award interest. Arbitrator has discretion to award post interest on part of the sum. So the arbitrator has power to grant interest only on the principal component. Our arbitrator has power to grant interest on both principal as well as interest component in pre-award period, my lord. And in my case, my lord, admittedly, arbitrator has not awarded interest on interest in pre-award period. Therefore, it will not become sum on the date of the award, my lord. And the learned arbitral tribunal has gone beyond the decree. In awarding interest on interest, the field is covered by Morgan Securities in this matter, my lord. Morgan Securities has interpreted this aspect. Unfortunately, this judgment was not placed before the learned commercial court, and this judgment explains the concept of Heather Consulting, my lord. If your lordship will see the judgment of the Heather Consulting, which has been quoted by the in the impugn order, my lord.
Yes, if that be the thing, let Mr. Jindal respond.
This is one aspect of the matter. Second, my lord, why have I come into 227, my lord? Briefly, I have to say that there is no provision of appeal under section 37 of Arbitration and Conciliation Act. I have no remedy, my lord, and this is the only remedy, my lord. I have the authorities on that point. If Mr. Jindal has some objection, I will satisfy your lordship on that point. That is all I have. Let Mr.
To what extent we can go in?
Yeah, the lordship will go because if that is the issue, my lord, that in all matters of this nature, my lord, I have cited the judgment of Bombay, Calcutta, our own High Court, saying that whenever this kind of issue is there, the discretion is exercised under 227. I am supported by the authorities of Supreme Court. I have in commercial matters only I have the judgments. I have put it in compilation also. I will place those judgments also, my lord, to show that any order which is a case where the district commercial court is going behind the decree. So exercising the power which is not vested in the commercial court. So it is a case of usurping the jurisdiction which is not vested, because if the decree says that the claimant or decree holder is entitled to X amount, my lord, the commercial court cannot read X plus 10. If 10, then 10 will be amounting to rewriting the decree and going behind the decree, which is not permissible in law, my lord. And therefore, your lordship has the power under 227 to examine this aspect. I will satisfy this. This is the only remedy under the Commercial Court Act and Arbitration Act. There is no other remedy, my lord.
Yes, Mr.
And
Lordship, I'll first take to your Lordship the operative part of the award which my learned friend has referred to, page 68.
Now, what about this thing, decision of the Morgan Securities?
Which one?
The decision which learned AG has
This
relied
is the
upon.
two-judge judgment.
But then
And
the thing
there
is
are
that
three-judge judgments.
it
Three-
verifies
I'll satisfy your honor. This,
that
this
Hyder
judgment has,
Consulting.
in fact, supports my case.
So we'll do one thing. We'll keep it for hearing then.
We are hearing only.
It has come for motion. You want to finish the matter today?
No,
It's okay,
no,
no problem.
no,
If you want to
Chief.
go ahead.
No, Lordship, not that.
Yes.
Hearing means, your Lordship, hearing on motion or hearing on motion?
See, you are a cavator, isn't it?
Yes, Lordship.
The law says that no order can be passed without hearing the cavator,
Yes, Lordship.
isn't it?
Lordship.
Now, you definitely have the right to oppose the motion.
Yes,
So your objection has to be to the motion. Until and unless you show us that this application is not maintainable at all, then we may proceed ahead. We can fix it for final hearing.
No, Lordship, I will humbly submit that this petition is maintained.
So there is no
No quarrel on that.
yes.
Unnecessary quarrel I don't want to raise
Yeah, that's
because
No,
law is very clear.
senior
But
counsel should not
once,
do it also.
Once there is no remedy available, the last resort is 227, which is a constitutional provision, and no legislation can cut down that provision, which is conferred under 227. But this is a question of scope, which is limited.
Exactly.
Scope is limited. Now here what my learned friend is arguing, he says that the court has gone, the executing court has gone beyond the decree. Beyond the decree. My respectful submission, your lordship, is this: the learned court, executing court, has not at all gone beyond the decree or beyond the direction passed in the award. And if your lordship is satisfied of this point, and there are this position of law, your lordship, has recently undergone changes because of the Hyder Consulting case. Otherwise, prior to that case, position was this, that the SL Aurora versus State of Haryana was the leading judgment, which says that interest on interest cannot be awarded. Interest on interest cannot be awarded. And that judgment hold the field. Later on, 3-judge bench judgment in Hyder Consulting has changed the position of law. They say that when you add the interest into the principal amount, when you add the interest in the principal sum, that interest becomes part of the principal sum, and it cannot be said that there is a interest on interest.
That is what seems the commercial court has followed. That proposal.
Commercial court has followed that principle because that principle now hold the fields. And subsequently, your lordship, because the Hyder Consulting case was decided by 3 judges. 2 were on one side, and Justice Sapre has given a concurring judgment. Justice Bode, he differed. But it is the majority view which has to be taken, and that becomes the law, your lordship. Subsequently, in UHL case, it was further held. They have approved the Hyder Consulting case and has specifically said that SL Aurora versus State of Haryana is overruled. It is wrongly decided. The position is this, your lordship. There is no denial of the fact. If your lordship read the operating portion of the award, there is no denial of the fact that the arbitral tribunal has awarded interest both for the pre-award period and the post-award period. My learned friend will not dispute on this point that tribunal has granted pre-award interest and the post-award interest. The difference between these two is only this, that so far post-award is concerned, the tribunal has said that there will be increase from 12% after every 3 months.
If it is not paid within 90 days.
If it is not paid within 90 days. That is the difference. And the tribunal has awarded the post-award interest. Now the dispute which lies is this, that there is no dispute about the principal sum and the interest accrued on the principal sum till the date of award. There is no dispute. No dispute. Now, the dispute starts from the point when post-award interest is taken into consideration. According to my submission, or according to the judgment of the trial court, the amount awarded is principal amount plus interest, and post-award interest is to be calculated on that amount. And that makes more clear if your lordship see section 31(7). Your lordship will just take 2 minutes time.
Mr. General, if it needs detailed hearing, then definitely let us post it for hearing.
It will require detailed hearing.
But your lordship,
It seems, and at least especially
no,
for this court.
there should not be a
Especially
stay
for-
here. There should not be a stay because it's a money dispute.
No, if we do not
I
give a
have
stay, then
paid
what is the
you-
purpose of then admitting that?
No, your lordship will pass an order which serves both the parties. Let them deposit the amount, and I will not withdraw. And
Because I am a
that is
great
what
lord.
is the
I am not
principle.
running away.
Your,
I have paid the
Mr.
entire digital amount.
Mr. Kumar, kindly give me 2 minutes. 2 minutes time. Your lordship, the law is very clear on this point, that a money decree, if it is to state security in the form of deposit of the amount,
We are
is
not-
to be given.
We are not staying in decree right now. You see, the problem is that the calculation. That is why.
Calculation, yes, the calculation,
Whether
your
the-
lordship, even calculation,
Whether
there is a
this
calculation
free
there.
interest
Your
will
lordship,
form a part of
your
the
lordship,
principal
the
amount.
calculation is also not in dispute. It is the method of calculation. Method, he is telling one method, I am telling other method. The Supreme Court, the constitutional 2 benches judgment are telling that when the interest is to be added, just your lordship will have a section 31(7).
Give me arbitration act.
31(7)(a). 7(a). Your lordship will see the phraseology used there. 7(a).
Yes.
Unless otherwise agreed by the party, where and in so far as an arbitral award is for the payment of money, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. This provision, your lordship, is discretionary, and further your honor will find that this provision is subject to the agreement to the contrary between the parties. Parties may agree that no pre-award interest will be paid. It is not a statutory provisions which binds the arbitrator to award pre-award interest. If the arbitral tribunal finds that there is an agreement or there is no reason to award pre-award interest, then the amount awarded will become both principal and interest, because interest is not
That will
awarded.
depend on the situation.
Situation, Your Lordship.
Now,
And-
we are
and-
not going behind the decree. You see, the decree stands as it is.
Huh.
But what this decree should mean, that is what is to be.
Yes, Lordship. That's why, Your Lordship, my respectful submission is there, Your Lordship, that it is also in the interest of both the parties, that otherwise interest per day is being accrued. And per day interest is coming around 9,000 per day on the balance amount which is there. Now, the moment they put up this amount in the fixed deposit or in any other deposit, what Your Lordship directs or what the executing court thinks proper, interest stops. And I am making a statement that I will not withdraw the amount till this is settled, Your Lordship. Till this is settled. And this is, Your Lordship, in pursuance to the Order 41 provisions, which is applicable in CPC.
It's already applicable, yes. You do not have to show it, yes.
Lordship,
It is applicable. It is.
it's applicable. It's applicable.
I don't think there will be any dispute with regard to that.
Yes, my lord. Yes, my lord. I have
Yes,
I agree
Lordship,
to what my learned friend says, my lord.
because
I
Your
agree to
Lordship,
what my learned friend
when
says.
Your Lordship is admitted this civil admission, Your Lordship will also have to pass some staying the money decree. And for staying the money decree,
No, we will not stay it. We will just stay the execution proceeding till the
that
final hearing.
it amounts to same thing. If
And
the
we-
education proceedings are stayed, then I cannot proceed.
See,
So this has to be stayed, Your Lordship, subject to certain conditions. And it cannot be stayed in a blanket manner. That is what is the provisions of Order 41, which is applicable, says that even for filing the appeal or revisions, they are to first deposit the created amount if it is a money decree.
are you equating this 227 application with an appeal?
No, you see, the
It is not a
provisions will be
statutory
said.
appeal.
No, Lordship.
What is provided in section Order
Lordship,
41?
I may respectfully submit, Your Lordship. It is not a proceeding for appeal. It is a other proceedings under Article 7. What CPC says, that for other proceedings also, the principle which are applicable will apply. In the missed case, supposing we file a missed case, Your Lordship will see one section which says that in all proceedings,
I am not disputing what my learned senior is saying, my lord. I am not disputing what my senior
Your
counsel is
Lordship,
saying.
I'm sure, Your Lordship, I have done few cases. I have the privilege of listening my friend on 3-4 occasions in such matters. I have learned a lot from him. And
I have also learned a lot from learned senior counsel, my lord. That's
so,
mutual
this
appreciation.
proposition, Your Lordship, what I am placing is the law of the land and which is followed in this arbitration matter. Your Lordship, from the last 10 years, I am hanging with the decree. They do not pay the money. No,
They have paid part of it. isn't
no,
it?
they have not paid it. No,
Entire digital
no,
amount.
no, they
Entire
have
digital
paid it
amount.
now. I am telling, had they paid it, at the time when it was required to be paid, 131 was the total amount, and now it has gone more than 4 crores. 4 crores.
294 lakh rupees, 98 lakh rupees I have
No,
already paid. Digital amount, my lord.
even we are
Digital
paying.
amount.
We are paying because decision is not taken by the authority concerned.
Anyway, you have been paid some money.
No, I have been paid. I am
Entire
not disputing, Your Lordship.
So-
The point here is this: 1.50 is outstanding. 1.50 is outstanding, and first of all, Your Lordship,
see,
there
according
is
to them,
there is
according to
no
them,
there is
just a
no there is no stay application filed by him.
That is not required.
No,
nowadays.
of course, in the main
There was a
petition.
time when it was mandatory. Now it is
My
not mandatory.
only respectful submission is this, Your Lordship. I am citing Order 41, Rule 3 and 5, which specifically says that money decree is to be stayed only when
We are not staying any decree in its entirety. The facts remain is that you have received a part of it, isn't it?
Just lordship.
So
Entire
the
amount.
remaining part, according to here the dispute is different. You see, according to the contention of Mr. Kumar is that decree stands satisfied. Now, so far as you are concerned, you say no,
Yes,
it is not satisfied.
and balance amount
So,
is there.
That is where. So things stand.
And one judgment, your lordship, of the court is in my favor.
that is all right. That's all right. But then the
In my
issue needs to-
favor, and the balance of convenience is
issue
in
needs
my
to be
favor.
adjudicated. You see, issue needs to be adjudicated. That is the main.
No, that's what your lordship. I'm not stopping. I'm not taking away that money. I'm not taking away that money, but provisions of the law are required to be satisfied, your lordship. But the law says, your lordship, is something very different here.
Come order 41 rules.
Order 41. Your lordship, first your lordship will come, order 41, rule 3.
Yes.
Where the appeal is against a decree for payment of money,
Just a second.
the appellate
just a minute.
shall.
Just hold on. Hold on.
And the link for application is found under section 36 clause 2 of the Arbitration Act. 36(2) says that it has to be treated as a decree and provisions relating to the decree shall be applicable.
Yes, that is all right.
That is in the arbitration. I am telling
so far as
how does the CPC comes into picture. That comes because of section 36(2).
Yes. Now we are referring to order.
Order 41, rule 3.
Yes.
Where the appeal is against a decree for payment of money, the appellant shall, within such time as the appellate court may allow, deposit the amount disputed in the appeal or furnish such security in respect thereof as the court may think fit. That is, your lordship, the first requirement. Then your lordship will see order 41, rule 5, stay by the appellate court.
You have read out just now order 41 rule 3.
3.
Which is rejection of amendment of memorandum.
Yes, no lordship. 3, form of appeal, then thereafter contents of memorandum, then
You are reading order 41,
sub-rule
isn't it?
3. Sub-rule 3. Where the appeal is against a decree. Lordship got it?
Order 41 from original decrees. Number 1, the rule 1
The
says.
form of appeal.
Yes.
Then number 2, contents of memorandum.
Then you see, you are referring to rule 1, sub rule 3.
Sub-rule 3.
Not rule 3.
No, sub-rule 3. Then, your lordship, I am referring to rule 5.
See, we are not dealing with an appeal.
No, that's what your
That is
lordship.
what it is about of
That's what I am. Your lordship, I was trying to point out the
Mr. General.
sections which says that in all proceedings arising under the CPC.
Kindly appreciate one thing. This court is not, you see, exercising its appellate jurisdiction. So even the rule 5 also will not come here.
No, lordship, that
This is a constitutional provision, isn't it? 227.
227 also.
Will it be
Your
bound by
lordship,
the? Will it be?
lordship, in 227 also, the procedure prescribed under the CPC has to be followed. So as in,
Are you equating 227 with the 115 CPC?
no, both are scope is different. The scope
exactly
is
why.
different.
The scope is different.
Otherwise, both are revisions.
Anyway, we'll admit this for hearing, and meanwhile, just this let this execution proceeding remain straight.
No, your lordship, I am.
And we'll give it expeditious hearing. That is the only thing, you see. You have to be nothing.
No, your lordship, for deposit there should not be any difficulty.
Deposit is not see mandatory so far as 227. So this
Then let him furnish bank guarantee security. But there are two things which are mentioned: either deposit the amount or furnish security. No, your lordship, let us have a compliance with the law.
No. Wait. Which row is required to be complied here? Just say, show us. Point it out.
Lordship,
Which law to be complied with? Just show.
your
point it out.
lordship, which I sub rule 3.
It applies in where the appeal is against a decree for payment of money.
That's
Here
what
there
your
is no
lordship-
appeal has been filed. See, decree is no way under challenge here.
Decree cannot be, because this is a revision.
Exactly.
Otherwise,
That is the
otherwise,
admitted position.
no. Just give me 1 minute.
You want to say that 227 will be guided by the principles of Order 41?
Yes, your lordship.
Where is that law?
No, I'm showing.
Just give us.
Please.
Because ultimately, if the petitioner fails, they will have to pay you the entire thing.
And plus interest also.
Plus the rate of payment, they will have to pay the interest. So even if senior counsel's prayer is exceeded to, he will take the risk for that. He will have to pay the interest.
Yes, my lord. Yes, my lord. I have to pay the interest.
I do not know why you are opposing to that, and even if you agree with
I'm not
Your lordship, I
indicted.
have been depositing.
I'm not-
I have been depositing money in all the cases
See,
there.
even and that you see, Order 49 Rule 1 sub Rule 3. If you say even it is applicable, assuming it is applicable, it is not that you have not, you have received a part of part payment of the decree. It is not a case that no money has been.
My case is the entire decree has been
Let
satisfied.
us decide this issue, and this will be learning for the court also.
Running for the court also, and moreover, your lordship will this will set a precedent. Not because the disputes are arising on the question of whether the amount, whether the interest accrued in the pre-award period has to go with the principal amount or not. Because Supreme Court also is not very clear on this issue.
Yes,
I
exactly.
respectfully
You see,
submit to your lordship.
it seemed to me also. You see,
Is not very clear. Unless some larger bench comes and say something different. And we have only two judgments of the constitutional bench consisting of 3 judges who have touched this point, and they have touched this point, but in the law commission this point was I'm just in the law commission, your lordship, this issue was raised, put that whether this is whether the interest accrued in the pre-award period is to be counted or not for the purpose of calculating the post-award interest. Even law commission opined that this has to be done so as to check these PSUs and other big companies to pay the arbitral amount. And this is a sort of directives to them, directives so that they do not sit over the matter. And it is for that reason that they said that Hyder Consulting case was rightly decided. It's the law commission which has also said that Hyder Consulting case is lawfully decided. And this part of the law commissioner report is cited in UHL case. UHL case.
And if whatever you say, if it is correct, then definitely the petitioner will not.
Yes, Mr.
Your Lordship, since Your Lordship
prima facie-
appears to have taken the view that to grant the stay, let this application be heard fully at a motion stage.
Lordship, may I hear the matter finally?
Motion stage, because this involves the substantial question, first thing, and second thing, my money is also at stake now.
Today itself.
Not today.
May not be possible.
To the day convenient to my friend.
We'll admit it for hearing, and then,
Yes, please.
as you know, court here is what? Moment, the day on which you are ready to take up the matter will be taken up.
No,
Yes,
we are
I'm-
always ready. Same thing, because it's a question of law here. So facts are not disputed. It's a question of law.
Anyway, heard, Mr. Kumar Lanet, Senior Counsel, assisted by counsel for the petitioner, and also Mr. K. Jindal, Lanet, Senior Counsel, assisted by so and so for the respondent. There is only one respondent.
Only one.
Yes, Your Lordship.
Only one respondent. Only one respondent.
The petition stands admitted. Let the matter be listed for hearing on which when do you want it for hearing?
After 2 weeks.
After 2 weeks?
Yes, Lordship.
Let the matter be
Maybe
listed
listed for admission hearing. You let we accept the notice. Stay.
for, we have said matter is admitted for hearing.
Admitted.
So admitted for hearing. This is matter for final disposal after 2 weeks. That will be final disposal after 2 weeks. In the meanwhile, the further proceedings in the commercial arbitration execution case number 2 2024 shall remain stayed.
Grateful.
He has not
We are
asked
not
for the
passing any
stay.
detailed order at this stage, Mr. Kumar. Of
Yes,
course, you
Lord.
can record your thing, but then
Yes.
since it will come up for final hearing after 2 weeks, so we'll just pass this.
Yes, my lord. I am ready. In
Then
fact,
till
I have
the next
prepared the
date it is
compilation
stayed.
also.
Till the next date.
That is what we said. Till the next date also.
It is stayed.
Till the day. I am prepared. Compilation is also ready, my lord. Compilation I have also given to my friend also. So I will argue on the basis of
What is the last
compilation.
line? Just a minute. Just a minute. What is the last line? Oh, in the meanwhile, only.
Till the next date.
Oh, so still remain till the return of it.
Till the next date. Highly obliged, Your Lordship.
Grateful,
You
my
have
lord.
to,
Grateful.
Mr. Jindal,
Lordship.
you have to basically make this court learn.
Lordship,
From
I
the
will do.
basic
I will do. Your Lordship, I will do to the best of my capability what I have done, and I understand Your Lordship that possibly
Because
Your Lordship has also
Both of
not
you are
taken-
expert in this arena. And
Not
probably
expert.
You have been made to argue before a
Not
court.
expert, but I enjoy arguing with my friend. With my friend, highly obliged. Whether I win or he win doesn't make a difference.
Item number 2. number 2.
May it please, Lordship.
Yes.
Lordship, this matter, Lordship, there is a certain development. The dead body is being exhumed today. It started today. It's being exhumed today on the basis of the order passed by the.
What is the
District
matter
Court.
about? What is the matter?
It's
What?
for transferring of the investigation to another agency.
Your Lordship, what has happened here, Your Lordship, was that the son of the petitioner, Your Lordship, he has passed away, Your Lordship. We are alleging that there are certain ulterior motives, Your Lordship, that has been certain circumstances.
Passed away in unnatural circumstances.
Your Lordship, an inquest report has also been filed, Your Lordship. Investigation, the investigation, Your Lordship, the investigating agency, Your Lordship, had not arrested any persons, Your Lordship.
So whether to arrest somebody or not, that will be their prerogative.
Correct,
Or
Your
the thing is
Lordship.
that, or that is what the thing. Do you want to say that no case has been registered, or
No, Your Lordship, the case has been
It has been
registered,
registered.
Your Lordship.
and the investigation is going on?
It's going
Undergoing
on.
on, Your Lordship.
And
As of right now.
they have raised a protest before the district judge. So on the basis of their protest, the district judge has passed the order to exhume the body. So it's being done today.
So that matter is again pending before district judge also.
It has
There-
been
You have to
pending.
invoke jurisdiction of both the courts simultaneously.
No, Your Lordship, the reason why we have invoked this court's jurisdiction, Your Lordship, was because, Your Lordship, previously, Your Lordship, we had come here also initially. Your Lordship, at that time, Your Lordship, the FIR was not even registered. A case had not been registered, Your Lordship, under section, under the relevant sections of law, Your Lordship.
After they have filed the FIR, Lordship, the case was registered. Initially, it was registered as UD case.
Okay.
Thereafter, they filed the FIR and it was registered and the investigation started. It's
But-
not that the investigation is sitting idle.
But Your Lordship, it took a very long time, Your Lordship. That's why, Your Lordship, it took a very long time for the investigating agency, Your Lordship, to come to a proper conclusion also, Your Lordship. And Your Lordship, we have also named, Your Lordship, the accused persons, Your Lordship, that we believe are involved, Your Lordship. But no action has been taken against them, Your Lordship. And these accused persons of Your Lordship have also acquired anticipatory.
After the incident,
Your
was
Lordship.
there FIR, any FIR lodged
No,
by you?
no.
We lodged it,
No
Your
FIR.
Lordship.
It was just
When the
information.
incident took place?
Your Lordship, Your Lordship, if you will look at Annexure 2, Your Lordship, page 18 of the petition. This case, Your Lordship, it happened in the year 2023, sometimes in February, Your Lordship.
No, FIR is 27/2/2023.
Your Lordship.
And then when the incident took place?
On the 25th of February, Your Lordship. Your Lordship, that is at the third line of the FIR.
And then who lodged this FIR? That is page 18, isn't it?
Your Lordship.
Oh no.
18. Oh no, Your Lordship, this is the, Your Lordship, page 18 is the, sorry, Your Lordship, it is the inquest report, Your Lordship, under section 174 of CRPC, Your Lordship. My FIR, Your Lordship, it is dated the 11th of May, 2023, Your Lordship. This is at Annexure 4, page number 20.
11th of May.
Your Lordship.
So after some times.
In the month of
So
May, it was filed.
initially, you did not suspect any foul play.
No, Your Lordship,
And
we
then
did, Your
after
Lordship.
3 or 4 months, suddenly
Yes,
you thought there is a foul play.
foul play.
No, Your Lordship, we did initially, Your Lordship. There was an assumption, Your Lordship, but Your Lordship,
There
these
was
people, an assumption, Your Lordship, that something had happened, Your Lordship. But what happened, Your Lordship, was that these pictures, Your Lordship, that I have annexed as Annexure 3, these were sent to the petitioner's daughter, Your
And
Lordship.
now if they are investigating the case
Your Lordship,
and the body has been exhumed,
Your
as per
Lordship,
your request,
Your Lordship.
when did you make the request before district judge?
The prayer was made by the IO, Your Lordship.
They raised a protest. Protest was raised by them. So the district
Protest
judge,
means what protest?
they have raised a kind of protest before the court.
What kind of protest and where?
In the court,
You
in
see,
the court,
your-
district
all
court,
these are
Lordship.
submissions appears to be very.
Lordship, in the district court,
in
Lordship.
what proceeding?
For that, Lordship, I have to obtain the instruction. Because I was told that they have raised a protest and the district court had passed the order to
What is
exhume.
the protest and when the district court has passed this order? Because if they are pursuing the matter with the district judge or district session judge there, then definitely this court will not exercise jurisdiction in this case.
The district court had passed the order, Lordship.
No,
Otherwise,
whether
without the order,
whether
the-
at their instance or not, that is the first thing.
Yes.
Second thing is that you have the knowledge of that thing,
Your Lordship.
that the body.
Has been exhumed, Your Lordship.
So
we
you have
do.
the knowledge.
They have the
That
knowledge.
means the investigation is going on.
Your Lordship, the main reason why, Your Lordship, we had filed this writ petition, Your Lordship, was because, Your Lordship, the investigating agency, Your Lordship, did not take it seriously, Your Lordship, after we had even filed the FIR, Your Lordship. So, Your Lordship, considering, Your Lordship, that we are alleging a case of murder, Your Lordship, which is a serious offence, where a person's life has been lost, Your Lordship. Your Lordship,
We can understand that.
Your
See,
Lordship.
but the thing is that if initial registration was just, it was this thing, unnatural death case, UD case, isn't it?
Your
UD
Lordship,
case.
UG case. That means suicide
Your Lordship, it wasn't a suicide,
or
Your Lordship.
Accidental.
isn't it?
Your Lordship.
So subsequently you come and you say no, this is a homicidal death. You file FIR.
Your Lordship,
And that you do after at least 2 or 3 months of the incident.
Your Lordship.
2-3 months.
Now what makes you to do that?
Your Lordship, we were grieving as a family also, Your Lordship. I hope that at least can inspire some sympathy from this court.
Sympathy, is it a legal consideration?
Not really, Your Lordship. But Your Lordship, what had happened
The
was
problem is that you see, madam, see the two things. The thing is that you can understand that it happens sometimes. The investigating authority, they do not want to, you see, enter into any investigation
Your Lordship.
until and unless it is called for. And there may be a tendency of, closing the case immediately after the incident. But then you being a family member is expected to be alert in this situation.
Your Lordship.
Now, if you expect some foul play, the normal assumption is that you will lodge your complaint immediately. You do not do it. Now, you do it later, and then you try to pressurize the investigation to make out a case. Either this way or that way.
But Your Lord,
So, supposing if in case where it's a genuine accidental death, and you say it otherwise, can you force the police to, you see,
no, Your Lordship.
at the best you can make a request for investigation.
agree, Your
which
Lordship.
is going on.
I agree, Your Lordship. Your Lordship, why we were pressurizing the investigating agency, Your Lordship, was because, Your Lordship, the facts of the case are like this, Your Lordship. Your Lordship, a group of friends, Your Lordship, had gone out for a picnic outing. Your Lordship, we had received a call, Your Lordship, from the friends saying that, Your Lordship, my son has drowned and he has passed away. When, Your Lordship, we inquired what had happened, Your Lordship, he said, Your Lordship, that my son had fell from a 10-feet cliff, Your Lordship, and he had fallen down to his death and died.
No
Your Lordship,
postmortem was
Your
conducted.
Lordship, I'll get to that. Your Lordship, when the body was recovered, Your Lordship, considering he fell from a 10-feet cliff, Your Lordship, we expect certain mortal injuries, Your Lordship, to be there on the body. There was none, Your Lordship. There was only a little mark behind his neck, Your Lordship. Now, even the postmortem report, Your Lordship, it did not say, Your Lordship, that he per se died of only drowning, Your Lordship. It was inconclusive, Your Lordship. That's why, Your Lordship, I have also arrayed the doctor who conducted the postmortem report, Your Lordship. Your Lordship, when the body was taken for postmortem, Your Lordship, under 30 minutes, Your
Doctor
Lordship.
has been served with notice in this case,
Yes, Your Lordship, he has been served, Your Lordship.
and he is not entered a pen.
No, Your Lordship. To that effect, Your Lordship, I have also submitted an affidavit of service of confirmation. Now, Your Lordship, considering he fell from a 10-feet cliff, Your Lordship, his clothes were okay. His watch was okay, Your Lordship.
Can the
How can
opinion
that
of a doctor be refuted by a non-expert?
No, Your Lordship. But Your
You-
Lordship, a
You have a
reasonable
medical
man.
background.
No, Your Lordship. But a Lordship, a reasonable man, Your Lordship, a logical person, Your Lordship, would it inspires the thought, Your Lordship, that if you have fallen from a certain height, Your Lordship, we also have to consider the terrain, Your Lordship. It won't be smooth. It won't be smooth, no, Your Lordship. There will be
On
certain.
what basis you say the
Your Lordship, if you look at the
deceased had fallen
pictures,
from certain height?
Your Lordship, if you look at the pictures, Your Lordship, that is at annexure 3, page 19. Your Lordship, the second picture.
Who has taken this picture?
Your Lordship, this was sent by the accused person, Your Lordship, to the daughter of the petitioner, Your Lordship.
It is dated after the incident.
Your Lordship. Your Lordship, he sent this
No, before the incident.
before Your Lordship. No, Your Lordship, it is dated the 26th, Your Lordship.
Yes, and 27th is the information, isn't
Yeah.
it?
Yes, Your Lordship.
26th February.
26th February, February, Your Lordship.
Yes.
Your Lordship, the second picture, Your Lordship, if you would see, Your Lordship, that little, it looks like a little,
No, but then what does the picture show?
Your Lordship, he indicated, Your Lordship, that the deceased had fallen down from the top of this waterfall, Your Lordship. And then, Your Lordship, they retrieved his body from the bottom of the waterfall.
But then the photo of the accused is not there, isn't it?
The accused person,
This photograph.
it was sent by who
that
we
is
are.
okay, but then whether this photo bears the photo of whether the disease is there in this photo.
No, Your Lordship. Your Lordship, he's showing the apparently, Your Lordship, his side of the story is that he's showing the sister, Your Lordship, where her brother fell from. Now, Your Lordship, if we look at the picture, look at the terrain, Your Lordship. If he had really fallen down from this feet, Your Lordship, it should have been that.
How do you know he had fallen from the top?
Your Lordship, this
He
is
might have slipped from the middle of somewhere.
No, Your Lordship, this was
Anyway,
what.
this is not for us to these things. Yes, is it for hearing? This
No,
matter
Your
is
Lordship, it's fixed for orders, Your Lordship.
But what for these orders?
Your Lordship, the state was supposed to retrieve certain instructions, Your Lordship.
Yes.
Lordship, in this matter,
Yes.
I have.
And he has taken instruction and he said that the
investigation is
underway.
underway.
When the body was exhumed?
Today.
So what will be your submission at this stage?
Your Lordship,
You are not refuting the submission made by him?
no, Your Lordship, I'm not
Then?
refuting. Your Lordship, let me also seek a.
Okay, we'll just think. You just take instructions and just
Yes, Your
inform
Lordship.
these things. Yes, Mr. H. Kharmi, London PP, APRE, on instruction submits that the investigation in the matter is going on and the body of the deceased has been exhumed today on the basis of the order passed by
District Judge.
district judge or session judge.
Session Judge.
Was by session judge, which place?
This is William Nagar.
William Nagar.
William
Your Lordship.
Nagar. William Nagar.
He submits. He therefore submits that there is no negligence on the part of the investigating authority to proceed with the investigation stuff. MS D. Maury.
D.F. Maury, Your Lordship.
D.F. Maury. Non-counsel appearing for the petitioner. 6. Grant of some time for taking instruction. Stop. Prayer allowed. List after.
After Easter, Your Lordship. After Easter?
After
2 weeks, Lord.
List after.
2 weeks.
2 weeks.
You take instruction. You see, if you find that investigation is going on, there is.
Your Lordship, the problem here, Your Lordship, is that Your Lordship, we have to keep on coming to court, Your Lordship, for the
And
investigating
that is
agency
their
to
mere
take that.
allegation,
No, but then
Lordship.
now,
It's not a
if the body is
allegation.
exhumed, that means the investigation
But
is
Your
going.
Lordship,
It's going
after
on
Only thing is
sincerely.
the problem is that, madam, you see,
Your
since
Lordship,
there is a lapse of considerable period of time.
Your Lordship,
Even if we direct any other agency to take over the investigation,
Your Lordship,
what will come?
Your Lordship.
By now, entire evidence will be erased.
Hmm.
For transferring the
Think
case.
about,
also,
think
Lordship.
about. You see, if your basically effort is to find out the truth, then think about all those aspects
Your Lordship,
and be rational in your approach.
Your Lordship.
It should not be something like that you come to the court, you must win a case.
No, Your Lordship.
The case has
Understand.
specific purpose, isn't it?
Your Lordship.
It is not like an ordinary litigations where the relief of some other aspect is straightforward. Anyway, just
Oblige, Your Lordship.
No, Lordship.
Item number 3.
It's Lordship.
Yes.
As per the order dated 28/2/2025, I think Lineal Council is supposed to get some instruction. This one.
as per the order dated,
28 February 2025.
My lord, this instruction, my lord, that I have received, my lord, that a document which was furnished to me, my lord, that is there, my lord.
no, on the last occasion, time was granted to Mr. Day
Yes, my lord.
for going through the documents.
Yes, my lord.
Yes, that is it.
Yes,
Not for any
that
instruction.
yes, that was.
Yes. So you've gone through the documents.
Yes, yes, my lord.
So matter is ready.
Yes, yes, my lord.
What is the matter subject? What is the matter about?
This is regarding actually this application. Actually, we have filed.
How long will it take?
Lordship, maybe this may come after 1 week because now maybe after some other day.
It will take long time.
May not.
There is a miscase for what?
This is the main case only for restoration of the petition. Actually, it's like main petition was dismissed for on default.
Yes.
So after 1 year, they have come on the allegation that because they are at the
Who
time
have,
of their
who have come for restoration?
I have come for the
Okay,
restoration.
so it was restored.
The matter has not
We
been
are
restored.
right now. We are with restoration.
On the
application.
restoration petition. my lord.
So restoration, why should it take some time, Mr.
Yes.
Sangma?
The-
Objection was
This
raised.
restoration along with the application for condonation of delay.
Yes, my lord.
Then delay is right now we are dealing with condonation of delay application.
Yes, condition of delay where the private
So our
respondent,
first step is to first
my lord,
deal with condonation application, and then if he is successful, then we come to the restoration.
restoration, my lord.
Yes.
Here, my
Now
lord,
you filed
the-
your objection to
No,
the,
we have not
they are
filed.
not
I
filing
am for the
objection.
district council, my lord.
Yes.
We are the authority who have decided, my lord. It is the private respondent who has filed an objection, my lord.
you filed an objection. Okay, so you are not filing any.
No,
objection.
my lord.
So
It
you
is.
do not have any serious objection to the.
Why we have no serious objection on this, my lord.
What is the ground of delay, Mr.
On the ground of delay,
You are
we
ready.
have cited that
You are not ready. We're ready or not ready?
Not ready, my lord, because just other.
No problem, grant of time. Just say these orders are passed only in this case, isn't it? 108. Yes. For how long this petition is pending, Mr. Sangma?
It's been pending quite
From
long.
2024, my lord.
My God. This
Here-
was done
here because-
by other court also.
Yes, my lord.
Only
This
because
restoration application was filed before the other court. And then it is still now pending before this court also.
before it was filed at the court, then it come again. We file it again. It go that side and come back this side.
There are some order sheet. Shows
Yes.
the signature of court number 1 here.
Yes.
Yes, yes, sir. As requested by Mr. Pretty Sangma Learned Counsel appearing to the applicant. Not objected to by the Learned Counsel appearing for the respondents. This is matter when?
After 1 week, my lord.
1 week, it will tell you the.
State is also a party. After
2 weeks. my lord.
Only if it is 2 weeks, my lord, then it has to go during the vacation. Let it be after 3 weeks, my lord. Let
there is
it go
vacation, it will automatically register
No, yes, my lord.
Can say
after 2 weeks. After 2 weeks.
lordship. First plus lordship.
Hearing item number 8.
Yes, Mr. Upadhyay.
Yes, Lordship. This matter may come up after 2 weeks.
No objection, Lord.
Two matters are there. Item number 8 and 9.
So, as per Mr. Upadhyay, Learned Counsel for the petitioner. This is matter after 2 weeks. Both the matters.
Both the matters.
After 2 weeks. Those case laws settled by Amit Kumar in the past matter. Those case laws only to this violation.